here.
Howdy do once again. Ask the Judge time. Judge Larry Thorne here. Always great to see you, my friend.
Great to be back. Great to be back.
You've got the answers quite regularly.
I have
We've
answers.
noticed. I've seen
Yes,
a pattern
I do.
here. And we have some great questions this week as well. Among them, this one. My old apartment did not require a deposit. They've now sent us a list of damages. It totals more than $500, but the itemized list came over a month late. Now, in that situation, I have to ask, do we have any recourse? What do we do?
Kevin, there was a person in my office who dearly loved, they've retired now, but they coined a phrase. It was confusement was the term, actually, and she was serious about that term, and I think this person actually does have a state of confusement here, because normally this 30-day thing applies when you do have a contract that requires you to put down a deposit. So usually you've got to, the person that's leasing the place has to give you that list within 30 days of you leaving in order for you to get your deposit back. This required no deposit. So,
and then they came back and said, bam,
yeah, they said $500. Well, I think the deal here is you've got, they've got to show that this wasn't normal wear and tear of the apartment. If the carpet's dirty, or maybe got a few stains on it that are normal stuff, walls maybe needed painting. I mean, that's normal wear and tear. So I certainly wouldn't pay $500 unless there was damage that could be shown that was specifically caused because of negligence or specific actions that you took to damage something.
If they had been hit by the storm, you don't get charged
for that. If this was storm damage, obviously it's not covered. I mean, they shouldn't have to pay it at all. The people ought to have insurance to cover that, but this doesn't make a lot of sense. Normal wear and tear, you don't have to pay that.
Yeah, that renter is confusified in some in some way. Another question. I resigned from my job. This one's serious.
Yes.
Resigned from my job because of the third incident of sexual harassment from the same person. I have reported it to HR, but what legal standing do I have despite my resignation?
This is serious, and that's one reason why we get a number of questions, as you know. And I wanted to address this one because it's more common, I guess, in the workplace than we'd like to, anybody would like to admit.
Yeah.
And it's certainly in the news. But they do have a remedy. What I thought was interesting and is significant is this was the third complaint. So apparently nothing was done the first two times.
Third documented complaint.
So what you do first, and you have to do this within 6 months, is file a complaint with the Texas Workforce Commission, the Civil Rights Division, and you file that complaint within 6 months. Also, I would see an attorney about it, discuss, of course you need to know, she said she complained to HR, what did they do about it? Did they try to stop the employee? Was there
so the resignation has nothing to do with whether they can...
Well, and I think maybe this question also goes to, can I get unemployment? Normally when you file for unemployment, it's got to be because you're fired. This person resigned, but you can ask for unemployment and file for unemployment as long as you can show this pattern of abuse, the fact that the HR or the company did nothing about it, and you've got a witness or persons that you've talked to about it and can come and testify, you may be able to get unemployment. But
what if that person didn't have a witness? Would it work?
It would be harder. It would be harder for the unemployment, not necessarily for the Texas workforce to document a complaint, because she went to HR and talked about it.
Well, if you have questions for our Ask the Judge segment, fill out our form at 12newsnow.com/ask ask the judge. We'll try to get to it. Judge Larry Thorne, thanks so much.
Sure.
We're back in just a moment.